Welcome back, everyone. Today, we're stepping into one of the most tense and emotional hearings we've covered in a long time. This is the case of the people versus Mirage Scott. From the very beginning, you'll see a defendant torn between seeking mercy and being confronted by his past mistakes. Scott enters court optimistic, talking about his family and support system. But don't let that calm start fool you. Things are about to get heated. We'll hear arguments about mental health, medication, family support, and whether Scott deserves to be released on bond while awaiting trial. The defense paints him as a man trying to rebuild, while the prosecution insists he's far too dangerous to trust outside those jail walls. And when Scott himself takes the floor, the emotions run high with a raw, almost desperate plea for another chance. So buckle in, because this is more than just a routine hearing. It's a battle over freedom, accountability, and redemption. And here's the big question for you, the audience. Would you release Scott if you were the judge? Knowing both his struggles and his history? Keep that in mind as we dive in.
Feaster on behalf of Mr. Barrage Scott, who is approaching from the podium. Mr. Scott, please state your name for the record.
Well, I was gonna say Scott, so.
How you doing?
All right, just glad to see my family in here, that's all.
Thank you, Judge.
Been here every time for you.
Yeah.
All right.
Thank you, Judge. I believe this is a competency review. My understanding is that we do have a report that is competent, Your Honor.
Yes.
We stipulate that, Your Honor.
And the people?
But also stipulate.
All right. The court, having reviewed the report, would find that the defendant is competent to stand trial. The defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is found competent.
Judge, I'd be asking this might be set for a PCC, and Mr. Scott would like me to address bond as possible.
All right. Probable cause conference will be set for July 10th, 2025, 9 a.m.
Thank you, Judge. I've had a chance to talk to Mr. Scott about the situation, and I've relayed to him how serious of a charge he is facing. Mr. Scott is still asking that I seek a personal bond for him on this case, Your Honor. Although the court does see that Mr. Scott is competent, Mr. Scott does indicate that he suffers from a variety of mental health conditions. He indicates that he would love to get this situation resolved. He would love to see the prosecutor's office potentially offer him a mental health court resolution. He says that he's not going to run from this situation. He has family support. He indicates that his mental state is in a much better place now than it was at the time of this alleged event. He indicates that he has a grandmother who is involved in his life and who will help make sure he attends any and all court dates. He indicates he will go to any outpatient or inpatient treatment that the court does require. He also has no objection to being on a tether.
This is where things get interesting. The defense lays out a strong case. Scott is medicated, stable, supported by his grandmother, and even willing to wear a tether if it means his release. On paper, this looks like a defendant trying to prove responsibility. But here's the key detail: bond isn't just about family support or willingness. Judges must weigh public safety and flight risk. Scott has a history of failing to follow through after being given chances. And that history may outweigh his promises today. So let me ask you, if someone you cared about struggled with mental health and made mistakes, would you believe in second chances? Or do past actions speak louder than present promises? Drop your thoughts in the comments, because this is one of the toughest balancing acts in criminal law. Rehabilitation versus public safety.
He indicates he's willing to just address everything that's going on in his life, Your Honor, that he will not be a problem for Your Honor should the court release him. He's asking that Your Honor consider a reduction in bond or a potential personal bond. But again, I have relayed to him how serious of a charge he's facing. But I believe that's what you want me to argue. Anything else? Mr. Scott says that he's on his medication now, and he's obviously much better when he's on his medication than he is when he's off his medication, and he will stay on his medication should the court allow him an opportunity to be released. And that the nurses in the jail have upped his medication in certain areas and have him on a shot and a pill form.
Yes.
And so his mental mind frame is in a better place, and he will do anything and everything the court asks that he's asking for potential release.
Response.
I would ask that bond remain as currently set. I appreciate Mr. Easter's advocacy on behalf of his client. I'm struck by the language in the competency report. Mr. Scott affected a volitionally cooperative, unself-regular evaluation process to feign legal knowledge, memory deficits, and symptoms of secret. Candidly, if you're uncooperative in the underlying competency evaluation, given his criminal history and the facts of this case, I believe that he is a danger to the community and has remains.
Nothing further, Judge.
All right. I am going to deny the defendant's request for a bond reduction in this case. I think the bond is set appropriately. I would further indicate that Mr. Scott's been appearing before this court for quite some time on various matters, and typically I can let Mr. Scott out of custody and come back in, but usually for minor things. Mr. Scott was in custody. I took a chance, released him. He did not make it a week. This came up, Mr. Scott was arrested. So I'm not going to take that chance again, especially since it's
You understand what he's saying to you?
violent case.
Hold on, do you understand what he said to you?
So
He said that he let you out. This happened a
I
week later.
know, but he keeps saying the same.
Okay.
Saying the same thing that he said.
Okay. I believe Mr. Scott wants to address you directly, Your Honor, if you'll.
go ahead, Mr. Scott.
Listen, Mr. Simpson, I know you kind of keep, going back in the past, right? But this is my life. You know what I'm saying? My grandma's here, my family's here. People are making me look bad. Even a competency hearing, they're making me look bad. I answered everything what I was supposed to answer the right way, and the prosecutor saying I was I wasn't cooperating the correct way, and I was. It seems like I had to take 2 competency tests. And the first one, he just said what he wanted to say. I'm asking if you release me today, because I gotta go see Slay today. They said if I do get released, they're gonna follow the same recommendations you will follow if they put me on tether, if they put me in. You never put me in no classes. You never ever put me in no classes or try to do anything like that. I want my days to be filled. If I'm on tether and I have a curfew, I want my days to be filled. I be with my auntie, stuff like that. I go to classes. I go to Don Farms. I need this. I need help. I have a drug problem. I never addressed it like this. But after my sister died last year, she died. She had passed away at 23. I went crazy. I didn't understand half of the things. She had heart failure. It's my grandma. She's 70 years old, something like that. What would happen if you keep me in here and then she just something happens?
Scott,
No, listen.
Mr. Scott, no, you listen. No, you listen.
But
I'm done. I let you out. I gave you a chance. I've given you numerous chances. Saying that anybody's trying to make you look bad, I don't have to go to the past. I let you out. You don't make it 8 days, and now I have you involved in a crime that involves pointing a gun at another person. I'm done.
what do you mean? Listen, can you just let me
Motion for bond reduction denied. Bond will continue.
Thank you, Judge.
But you ain't let me speak,
Go
though.
ahead, Mr. Ross.
And there it is, the hammer drops. Judge Simpson makes it clear. Scott has had chance after chance, and each time he stumbled. This time, the crime was violent pointing a gun at someone, and the court simply can't take that risk. Again, despite his heartfelt plea, despite his grief, Despite his willingness to seek help, Scott will remain behind bars. This hearing shows us the brutal reality of bond hearings, a clash between compassion and caution. On one side, a defendant claiming he's ready to change. On the other, a court remembering his history and protecting the community. So what do you think? Was the judge right to deny bond, or should Scott have been given one last chance under strict supervision? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Until next time, stay tuned for more real cases that prove the courtroom is where drama meets justice.
You ain't even let me speak.
Thank you, Judge.